All right. All right, ready? Good morning. Call to order the meeting of the South Carolina Board of Barber Examiners, December 8th, 9 a.m. Public notice of this meeting was properly posted at the South Carolina Board of Barber Examiners Office, Synergy Business Park, King Street Building, and provided to all requesting persons, organizations, and news media in compliance with Section 30-4-80 of the South Carolina Freedom of Information Act. The rules of the meeting are as follows. All cell phones and electronic devices should be on silent or turned off while the meeting is in progress. No outbursts or disruptions will be allowed by anyone during the course of the session. Person or persons are disruptives or habitually speaks out of order, they will be asked to leave the room, and they may be allowed to return at the appropriate time allotted on the agenda. Introduction of board members. Paul Robinson, Chair.
Renee Patton, Vice Chair.
Tony Holloman, Board Member.
Melissa Jones Horton, Board Member.
Staff present.
Mary League, Advice Council.
Tracy Adams, Board Executive.
Micah Hurt, Admin Coordinator.
Leanna McMenamin, Office of Disciplinary Counsel.
Renee Young, OIE.
April Howe, OIE Inspections.
And thank you for being here. We don't have any excused absences. You were sent the agenda in your materials. We will now entertain a motion to approve the agenda for today's meeting.
So moved.
Second.
Motion properly seconded that we approve the agenda for today's meeting. All in favor signify by aye.
Aye.
All opposed? Thank you very much. Approval of meeting minutes. The Barber Board, October 13th, 2025. If there are no changes or corrections, we entertain a motion to approve the Barber Board meetings for October.
So moved.
Motion and properly seconded. All in favor signify by aye.
Aye.
All opposed? Thank you very much. OJT overview meeting, November 3rd, 2025. We will entertain a motion to approve the minutes of that meeting.
So moved.
Motioned and properly seconded. All in favor signify by aye.
Aye.
All opposed? Thank you so very much. Chairman's remarks. I'd like to just take a moment of personal privilege. In my hometown of Orangeburg, we had a father and son barber shop owners who passed this month, well, 2 months apart. And the barber community is grieving for them. John Fair and Archie Fair, who's also a pastor down in Jedburgh. Barber executive remarks.
Good morning, everybody. For your review, a list of since October 13th through November 30th, you have around 2,200 master hair care specialists, 1,784 registered barbers, 3,700 hair braiders, close to 500 barber instructors. Total licensees around 8,200. The apprentices total around 397. Barber students or OJT 90-day work permits around 1,700. Barbershop schools 1,500. So a total of licenses for the Barber Board is 11,835. And then you can see the past 10-year review and the growth that has taken place for your review. It's about I think we said a 36 or 37% growth in the past 10 years. And then the cash report for your review.
Questions from the board? Much. Investigation and disciplinary reports. Ms. Young, OIE report.
Good morning, everyone.
Morning.
The status report, the complaints received, we have had 123 to date. Active investigations is 11, closed is 86. And this report is for informational purposes only. And we are asking for approval for the IRC report. Do we have any questions?
Questions for Ms. Young? Hearing none, we motion for approval of the IRC report.
I make that motion that it's approved.
Second the motion.
Motion properly seconded. All in favor signify by aye.
Aye.
All opposed. Thank you very much. Inspection report, Ms. Howell.
Good morning, everybody. The inspection statistics since last board meeting, we're going to start with October of this year. We've had 236 total inspections in October. We physically inspected 189 shops. 11 were permanently closed. 33 were not open at the time of inspection, and that included 2 schools. For November, we had 148 total inspections, 97 shops physically inspected, 8 permanently closed, 41 not open at the time of inspection, and 2 additional schools. So making the totals for the year so far, total inspections, 1,899, shops physically inspected, 1,460, permanently closed, 199, not open at the time of inspection, 338, and 24 schools. And that is for information purposes only.
The 199 that's permanently closed, do you find that scattered throughout the state, or is it?
It's pretty scattered. Yes,
pretty
ma'am.
scattered? Okay.
ODC report, if there are no other questions.
Good morning, everyone. Leanna McMenamin on behalf of ODC. We have 9 cases open, 5 are pending hearings and agreements. We have closed 25 cases total this year.
Questions from the board? Very much. New business. Consideration for a student permit, Brandon Fessler. Brandon Fessler. Yes, sir. Speak into the mic when it's your opportunity to speak, okay? Okay. This hearing is called to order. This is a matter of Brandon Fessler. Does any member of the board have reason to recuse him or herself from this matter? No. Purpose of this hearing is to determine whether Brandon Fessler is eligible to receive a student permit despite having a criminal background. Everyone is reminded that these proceedings are being recorded and that all witnesses must be sworn before they testify. All remarks should be directed to the chair. Ms. Adams, is the complete application package in our materials?
Yes, it is.
What questions did the staff have concerning this application?
Mr. Fessler is here representing himself and is requesting permission to receive a Barber student permit. Upon review of the application, it was determined that Mr. Fessler had prior criminal history and could not be approved at staff level.
Staff subpoena any other persons to be here today to answer any questions that we might have.
No.
The applicant is present. Mr. Fessler, would you please stand, raise your right hand to be sworn or affirmed, and give your full name to the reporter? Fessler, You were given written notice of this meeting today, and in that notification, you were given the opportunity to be represented by counsel, and you're choosing to represent yourself. Is that correct?
Yes.
Do you have anybody else here to testify on your behalf?
I have my boss here.
Okay. Boss, if you would like to testify, please come forward. Or if you're here for just support, you don't have to testify. Okay? Would please give your ID to the reporter. Okay, all right.
Mr. Fessler, can you identify who this person is?
Scarlett Dennis.
Okay.
She's my boss at my job.
Is that satisfactory?
It is, if it's okay with the chair.
Mr. Fest, ready to tell us why you should be granted a student permit?
Yes.
Go ahead, please, sir.
Long time, and I made a mistake, and I don't want it to like keep following me through my life. I haven't been in trouble in years, and this is just like a turning point in my life. So I'm trying to get my barber license so I can just move forward with my life.
Have anything you want to say on his behalf?
I think Brandon does a good job. He actually trained me when I first started at, we work in Forest Acres. It's a restaurant. And before I became the manager, he trained me, and then he went back to Indiana. And then I hired him back to come work because he's a good employee.
Very much. Do we have any questions from the board?
Yes, I do have I have a question on, are you currently in good standing with your probation? Okay.
I provided a letter to you guys also. They asked me to send a letter, my background, and anything else. I also got like certificates like in welding, construction, and warehouse manufacturing, just to show you that like I was, like just trying to better myself. But Barber, I want to do, you know.
Thank you, sir.
Morning. These, in reference to your dues.
No, ma'am.
Thank you.
Get that needs to be repeated? Okay, very good. Are there any other questions for Mr. Fessler? None? We entertain a motion concerning Mr. Fessler.
I'd like to make a motion. I'd like to make a motion to grant Mr. Fessler a student permit.
And I add to your motion, while you're still on probation until 26, December of 26, that you will provide the board a SLED report at the end of that year to indicate that everything is good and clean at
Okay.
your own expense.
Okay.
Motion properly seconded. All in favor signify by aye.
Aye.
All opposed. Thank you very much. The very best to you, Mr.
Thank you.
Fessler.
Just for clarification of that motion, is that because the board is concerned with the charges, that while he is on the right path, that the board feels like it's in the best interest of the public to ensure that he continues on that path? Is that correct?
Indeed.
All right, thank you.
Thank you.
Delvin Rowe. Delvin Rowe. Good morning, sir. Would you please give your ID to the reporter? Sir? This hearing is called to order. This is a matter of Delvin Rowe. Does any member of the board have reason to recuse himself or herself from this matter? The purpose of this hearing is to determine whether Delvin Rowe is eligible to receive credit for OJT hours that he obtained during the time that the barbershop license was lapsed. Everyone is reminded that these proceedings are being recorded and that all witnesses must be sworn before they testify. All remarks should be directed to the chair. Ms. Adams, is the complete application package in our materials?
Yes, it is.
What questions did the staff have concerning this request?
Mr. Rowe is here representing himself and is requesting permission to receive credit for OJT hours he occurred during July, August, and September of 2025. Mr. Rowe accrued these hours under a licensed barber instructor who also had the shop owner-manager at Jump and Barbershop. Upon review of the file, it was determined that the barbershop license had expired July 1 of 2025 and was reinstated October 2nd, 2025.
Staff's opinion, any other persons to be here today to answer any questions that we might have?
No.
Mr. Rowe, would you please stand, raise your right hand, give your full name to the reporter to be sworn or affirmed? Rowe, you received notification of this hearing today in writing, correct? And in that notification, you were given the opportunity to be represented by counsel, and you are choosing to represent yourself. Is that correct?
Correct.
All right. Explain your situation, please, sir, and demonstrate why you should get credit for these OJT hours.
Sir, honestly, I'm just asking for reconsideration, man, because I'm a real determined aspiring barber. You know what I mean? Like, I was a truck driver a little while ago, and things got ugly. So I had to, do what I felt was best for me. And I found myself in barbering, and then I started volunteering for the district. And that's the spot I needed to be in, because I get to, be around the kids and continue to mentor and stuff like that. And I was working and going hard since February at this, and I just received the email just saying, hey, these hours here not going to count. And I didn't have no idea of what was going on. And I felt like from the start, I've been doing everything I've been doing. And like I said, I went to truck driving school, and I also got my HVAC before that. So I got a lot of student debt loans that I couldn't afford to go through another schooling. You know what I mean? So I chose to go the OJT route, and I'm doing this out of pocket. And like, that's a lot of months, that's a lot of hours, that's a lot of man time, you know what I mean? Like, that's hindering me from being ready to take my test. And that's really all I got, man. I know I did everything I was supposed to do, and some kind of way it was a lapse, even with my hours being reported monthly, and nobody was told or whatever on that end, I'm not sure. But I also submitted some receipts where he went to pay something, and it was clearly written out, $265, but then right below that, it said $165, and it said for barber renewals. And he got, I also submitted the 2 barbering license and then the instructor license. And from what I gather, it was supposed to have been a barber license, instructor license, and a shop license. You know what I mean? I'm not sure. I'm just the bottom man on the totem pole, and I'm just trying to ask for reconsideration, man. I don't really know how it goes. Man, all I can do is ask.
Anything else? All right, you want to renew, you're currently still at Jump In? Okay.
And that's and one more thing. I continued to go forward, and there was we continued to turn in my hours. So I, if anything, what could be reconsidered? What could be reconsidered during that time of whatever would be. That's what I'm asking for.
All right, thank you very much. Any questions from the board?
I'm confused as to, as the hours, what is the problem? They weren't turned in?
Barbershop license was lapsed during this period of time.
But they were still turned in. They were still turned in monthly. Every month, they were still turned in. I got them here
got that.
stamped
We
and
got-
approved, but nobody said anything about the shop license being, lapsed. So I'm
Okay.
steady working and paying my money for my,
Okay.
OJT to get approved for hours, and, it's like null and void. You know what I mean?
Go ahead, please.
I would like to ask if we could have executive, we can have counsel from our attorney.
Need a second?
Second.
Motion properly seconded to go into executive session. All in favor signify by aye.
Aye.
All opposed? Thank you very much. Please clear the room. Thank you very much. All right, we entertain a motion concerning Mr. Delvin Rowe's request for student hours to be accepted.
Yes, I'd like to entertain a motion for Mr. Delvin Rowe training hours for the month of July, August, and September be approved.
Second.
Motion properly seconded. All in favor signify by aye.
Aye.
All opposed? Thank you very much. Very best to you, Mr.
And God bless. Thank y'all, man, so
Right.
much.
All right. Establish guidelines for granting a fourth student permit. Our previous meeting, we saw multiple students who needed or requested a fourth student permit. Typically been very strict on providing those fourth permits because there were a lot of abuse in the system, people continually getting permits and not completing or not taking the exam. So we need to create some guidelines for granting a fourth student permit. Have some input you want to give now, or we may even need to form a task force to create the guidelines.
Mayor? I would like to suggest that we create a task force.
I would also like to just add in some of the things to be considered in that. If it's no fault to the student, such as school closed.
That's what the task force will do.
Gotcha. Sure.
And keep that for them.
Okay.
After the task force is created, we establish meeting, have an open discussion, and then back to the board to approve it. Okay? All of you want to serve on that task force, we can also add other licensed instructors, maybe. Task force to maybe 7, no more than 7 people. A maximum of 7. Okay? That's good?
Mr. Robinson, are you asking for people to assess the interest, have individuals who might want to be on the task force contact the board executive, and y'all will vote on that at your next meeting?
2 months, but
We'd have a special called meeting to establish a task force. Once you got some people put their names in, because it does need to be, the people making up your task force would need to be voted on by the board.
holidays coming up, that's going to be tough. So,
We could always do a special called meeting by phone. I promise you, we can make it very easy.
do that. Let's do that. All right? Thank you very much.
Y'all just get the word out. Anyone interested?
If you can ask that they submit a resume, just to me.
Yes.
Is it too much work if we have this as one of the alerts on our website?
Heard him to what?
This opportunity to participate in the task force.
But sometimes you end up with a lot more to ask for. I think if y'all can get the word out in your community, then people in the as opposed to just everyone. I think y'all are really looking for the input more from school, on-the-job training instructors, people who have experience with students and the struggles they may have with completing course of study within a specific time period. Certainly welcome to invite everyone, But I wonder if that might be a response that's so great that it impedes your ability to get this moving quickly and doesn't really address the consulting qualities you're looking for. But certainly that's y'all's choice.
Yes, ma'am.
Only looking to invite barbers, or or including cosmetologists as well? Is it just barbering?
Just barbers, barber instructors, master haircare specialist instructors, registered barber instructors.
OJT school instructors.
Cosmetologists don't have student permits.
Other questions?
Get the names in. End of the week?
Maybe next Friday.
Next-
That'll give you a little bit of time. And like I said, I want to be able to have the resume so that way you can see their experience. And I'll put it on the board secured website so y'all have access to see their experience and how long that they've been licensed.
All right. Investigating review conference member consideration, you were given 2 individuals, both of whom we are familiar with, as well as their resumes. So that would, 2 additional members to that.
Correct. Right now you have 2, so this would give you 4. We would like to have 1 more person if possible, but this will help.
Questions?
Yes.
We would entertain a motion to accept Jessica Verapin and Angela Busby Morrison to the Investigative Review Conference. Favors? We
I make
entertain a
that
motion.
motion. That the 2 be accepted.
Second.
Motion properly seconded. All in favor signify by aye.
Aye.
All opposed? Thank you very much. All right, the establishment of student event guidelines. In your document, there are page guideline. I hope you had a chance to take a look at it. We'll entertain any questions that you might have about it. And then, once we discuss it, we'll vote. Yes, ma'am.
I don't see this as one of the bullet points of recommendations. Sometime in public schools, students are in the lab and they do not have permits for whatever reasons. So, is there a way that we can have that listed as one of the concerns that may happen in the future? For instance, in the month of January, we're having a fundraiser, and the students that will be participating in the lab will be students with permits. But we will also have guests as visitors who are professionals doing what do you call it when the professionals come in to share information?
Presenters?
Who now?
Presenters?
Presenters. So thank you, does that need to be a clause somewhere in these bullet points?
Not sure I'm following what you're asking. You're saying that some students at the public schools, barber students, are working in lab without a student permit?
That's one of the questions that I had for the bullet point, but not working. I'm going to use this for an example. Pictures are being taken in the lab for a stage for the yearbook. So the students are not working, it was just stage photos. So and those students do not have a permit. Not working, just there for photo props. And then the other comment that I made is that a gathering in the lab where professionals with license will be in there as guest speakers or demonstrating different cuts to show the students different styles of cuts, guest speakers during that time. Should that also be a part of this bullet point?
I think this document addresses off-campus functions. Off-campus functions. So, at a couple of meetings ago, there was a public service event, a community event at a barber shop. So this deals with when you move the student away from the licensed property, field trip, trade show, et cetera. That's what this deals with. Anything that's happening at the lab in school, it's a licensed facility. Hopefully, the people you're bringing in are licensed, and it's good for gaining hours in that situation.
For an example, if I may, in February, NABA will be hosting a student gathering. So these bullet points will fall underneath that gathering, where the students will be there off campus. Correct?
It's the instructor's responsibility. I think there's notification that has to be given to the board. And they have to be present. The instructor has to be present at this student event. Absolutely.
If the instructor's not present, but there is another qualified instructor, how would that level out?
Has to be an instructor of record. So if it's a substitute instructor, that person would be the responsible in person, okay? So it has to be, as I understand it, the instructors of record of those students that you're moving from public school, private school, barbershop to a community event where they're cutting hair, et cetera.
Competitions, so on and so forth.
Thing off-site.
Chair, can I, under student permits, so the way I read this, does that mean that while they're off-site or, at the location, their permit should be posted at that particular time as well?
I think they get a pocket permit just like the professionals. So they could have that, and it has to be.
Visible, okay. And my last question, under instructor supervision, when it talks about the qualified instructor to student ratio, so with an OJT instructor with their qualifications within the shop being 2 students, so that still follows, right? Okay, all right, thank you.
Other questions?
If those hours they went off campus, is that filed differently with their hours that they turn in monthly?
No, that you could still add them to their monthly log. We just need to know. Just all the instructors need to do is just send us an email saying there's an event, give us the brochure or whatever, so that way we know. We can put it on file for that student, and then they can record. Unless y'all think differently, I'm fine with just recording it on the same log sheet.
Okay.
Go ahead.
Thank you, Mr. Chair. And I do feel that we need some type of instructions for classroom instructions on the property or on the school property. scenario if one of our inspectors come in and we are not, because this is off of because this information is away from the property. But we have other events on the school property. So by me sharing this information, am I opening up a Pandora box? Because this is good and we need it, but we also need something in reference to programs and events that we have on the school property. Or will information be shared when the inspector come in, to just go ahead and share the information as soon as the inspector come in to say, this is what we have in today, here are the licensed people that are here to demonstrate or to be our guest speakers for the day? Or is it an understanding that because we know the proper protocol, that we don't need anything in writing to support the events that's happening on the property? And it's also another thing that I'm concerned about. We have students that the permits are expired, but the students are coming back to get the training for state board prep. So if an inspector walk in, when the inspector come in and the student has expired license, but it's a student of ours that we're prepping for state board, where are the information to guide us, or will we be classified will the student be classified as working without a permit?
This is, in my estimation, apples and oranges, okay? So what we have to deal with right now is the student event guidelines off campus. We can address any questions that you might have with the campus, and we have allowed public schools to be in control of that, okay? So we can come back to that at another point on the agenda, or if we need to bring it up as making an item for the next meeting, I believe we can handle that with no problem,
Thank you.
okay? Any other questions concerning guidelines for off-campus training experiences? Questions?
Accept these guidelines, because you're not really going to know until you step into this. How the response back to Tracy will be.
Right, we can always bring it back and make adjustments if needed.
Second.
Properly seconded that we accept the student event guidelines for off-campus training. All in favor signify by aye.
Aye.
All opposed? Thank you very much. All right, discuss instructors' late submission of monthly hours logs. All right. Adams?
Yes, so we have had an influx of instructors not submitting their student logs in the timely manner by the 10th. So I reached out to Mary and Teresa, trying to see what was done in the past. And what they had set up back in 2015 and 16 was filing a complaint against that instructor, and then Leanna doing a consent agreement with a $500 fine. I just wanted to kind of run that by you, to see if y'all are still in agreement with that, and if so, we will start doing that.
Personally, I'm still in agreement with that. That's what we
And so am I.
decided. And a message.
My question adding to that would be, would the board approve also as part of that, sending an e-blast to instructors and schools, reminding them they're due on the first day, that the 10th is a grace period, and that if they are received on the 11th, that disciplinary action will be taken, just to make sure everyone maybe straightens up, and hopefully we can cure the problem before we have to get
Refresh
too
their
deep.
memories.
Right, yes,
Yeah.
ma'am. All right.
Any concerns, any questions? Yes, ma'am.
I would like to share the gap that public school has with submitting hours. School is closed in a lot of public schools from May to August. So how would we support those students and instructors in public school?
Okay, help me.
If there's,
If the school is closed, unless the students are doing summer school, the instructor of record is still required to submit the hours. Okay, all right. What-
the issue is not an issue to my understanding, but I'm just want to share with the board some of the concerns that we have as public schools. The concern is that the teachers may not be at the school, so, and there still may be issues of students not being able to sign their forms. So do the board understand the gap for public school teachers? That sometimes the student teachers are not able to connect for whatever reasons. So if it's also added in the report that's going to be submitted to all instructors, that if there's a gap in some hardship between the teacher and students, to please notify the board in some way, so it won't be a concern when the teacher comes back in June, in August or the end of June. I'm not sure if it's even an issue, but I do know that it's a challenge getting students to sign the hours before they leave and to make sure that the hours are submitted in the public school setting.
Make any exception for public school, that exception will have to be given to everyone. Everyone has a 10-day grace period. All instructors, public, private, OJT, to get the documents signed, sealed, and delivered to the office. To, I've lost my, make a motion to accept the guidelines.
Make that motion.
Favor signify by aye.
Aye.
All opposed? Thank you very much. All right, board member training, Mr. Adams have put together a notebook with the information that board members need. So, Ms. Adams, would you care to tell us what this document is?
That's just your statutes and regulations, as long as you're a board member handbook, but actually the advice council, disciplinary council and OIE is going to do a board meeting training with y'all. It's a PowerPoint.
Questions? Sacramento State Barber Association,
We're just waiting on Billy to put it up.
oh, you're gonna do it? Okay.
Kind of a refresher for those. I know that Tony wasn't here. He was an IRC member, so moving into it. So we're trying to go back through and do a board meeting training for any questions that y'all might have.
Good morning again, everybody. All right, to start off, we're just, this is just an introductory slide just to show you who the leadership is in OIE. So Jennifer Stillwell is the Assistant Deputy Director. She's actually right behind us. Robbie Dean is the Program Manager over the Building and Business Boards. I am the Program Manager over Inspections, and then we have Bianca Smith, who is over the Health and Wellness Boards. All right, so these are just the different boards that we do inspections for, just really for your information. So we have a field, or a team that is throughout the entire state. They live in various areas of the state, and essentially these are the different boards that we do inspections for. So dental, they have dental sedation, dental mobile units, and dental portable units. The Real Estate Commission, Barber Board, Cosmetology Board, Massage Board, Funeral Board, and then optometry, excuse me, is just for their mobile units. So these are the various types of inspections. So for new openings, we do schools, of course. We have suites, that's more for cosmetology, mobile units, and then various businesses, barbershops, and whatnot. The routine inspections, so those are our essentially yearly inspections for this board. It is board specific, so every board has timelines that are different. For Barber, I believe in regulation it says it doesn't specify yearly, it just says as needed. I forget the particular word. And then reinstatements. So reinstatements are essentially licenses that have lapsed. In order for them to become licensed again, they do need an inspection. So that those are a reinstatement inspection. And then, of course, our reinspection. So if there was a previous closure, if there was a incomplete inspection for any reason, and then, of course, our failures, we try to get back and do those inspections within 45 days. So for our new openings, kind of to discuss that process and how that works, essentially once licensing gets everything they need from that applicant, that notification is sent to us up in OIE. And that assignment is usually within 24 to 48 hours. We get asked that question a lot. Once we get that notification. So again, once licensing has everything they need, an auto-populated email goes to us up in OIE, and then usually within 24 to 48 hours, we assign that inspection to the area inspector, and they are usually trying to get into contact right away with that licensee. We get that scheduled, and then depending on the circumstances, so for schools specifically, just as an example, sometimes they're not quite ready. They have a opening date of several months from now. So we schedule it based on that, or we just make sure that they have the inspector's contact information so that when they are ready, they can go ahead and get that scheduled. But then we will go ahead and do a preliminary and final inspection to ensure that they're good to go. This is just kind of the timeline, and there's the word periodically. Specifically, I think there's only one that actually has in their regulations or statute how often they are done. The rest are basically periodically. So dental sedation is every 2 years, and I believe that is the one that is actually written in regulation. Real estate, we are doing every 3 years. Barber, cosmetology, massage, and funeral are periodically, and then optometry mobile, I apologize, is the second one that is actually written in there that we do it yearly. So again, just a reminder, really, reinstatement inspections, they cannot operate until they've passed the inspection. So essentially, if we have a lapsed license and they are lapsed, they are not to be operating until that inspection is completed. That's another big question we get pretty often. And then as soon as the inspection is over and assuming that it passed, then of course they can operate. So there has been plenty of times, and the inspector really will communicate with them. But if, if they've got appointments already scheduled for the day, they get that inspection done first thing in the morning, then yes, they are okay to operate afterwards. But not until that inspection is completed. Go back one. Oh, hang on, no, backwards. Yep, there we go, sorry. I can't talk that fast, Billy. Re-inspection. So re-inspections are specifically for failed inspections or incomplete inspections. If they have a failed inspection or an incomplete inspection, they are able to still operate. So that doesn't shut anything down. A failed inspection doesn't change their operation ability. Essentially, we try to educate, ensure that they change any issues that we found, and then the inspector again will come back and re-inspect to ensure that the issues have been corrected. This board does not have citation authority, so this is speaking on some of the other boards. Again, this presentation is more general, but for this particular board, if the issues are continual and we continue to find issues, then at that point we would take them before the board or bring them before you. So this is just kind of a timeline to give you an idea. Initially, the inspectors will do some preliminary research. They're going to look at previous inspections. They're going to make sure addresses, phone numbers, all of those sorts of things are up to date. Looking at if there's any open investigations or pending hearings. We try to, if we have to, work with the investigative team to ensure that we're not going to interfere with an open investigation. And then just looking at the previous inspection report, some common issues, if there's trends, just having that knowledge ahead of time, they go in there, knowing that and looking for those specific issues that have been issues in the past. And then, of course, there's the inspection. So when I give the statistics every board meeting, we get those closed inspections. So essentially, if we go out to the place of operation and they're not open, or we're not able to actually do the inspection, that would be considered a closed inspection. And essentially, what we do is we just notate the time and the date, and then we reassign it for an inspection at a later date. What the inspector tries to do is obviously try a different day of the week, look at posted hours, try to do those inspections during those posted hours, and also communicate with the barbershop owner or manager to make sure that they're available the next time we come out. During that inspection, they are, of course, looking at licensees, looking at all the various things on the inspection report, of course, and taking any pictures that are necessary, making notes, and essentially the goal is to minimize disruption of business operations. We try, there's a lot of very busy barbershops out there, and we don't want to interrupt that busyness. But we do have to try to have that exit interview with the shop manager typically. So we essentially will go in, make our introductions, get the inspection done as soon as we can. If there are questions that we need answers to while we're there, they will politely interrupt, and then have that exit interview on the way out. And the exit interview is essentially whether they pass or fail, any issues they found, any educational pieces, if there was some, things that were minor but notable, they'll discuss them with them and kind of go over everything with them. citations doesn't apply. There are times where, there are some egregious things, so the inspectors will want to go ahead and initiate the complaint process, which Ms. Young will go over in a minute. But essentially, in those circumstances, a specified report is made by the inspector in addition to any pictures or whatnot to validate that report. Inspector will get the signatures, and then theoretically, the inspection is complete. They do, right now, we are actually reporting those daily, or at least within 24 hours. So the process or the system that we use is called Relays. It's the LLR software. So those inspections get updated within 24 hours now in the system, which is great. But essentially, they'll submit the report to me, include everything they've gathered, whether it's pictures or details, any of those types of things, and then I will do the final review, just look over everything, ensure that ensure that there's no further action needed. And then if there is further action needed, going ahead and doing that on behalf of the inspectors. So essentially, all the inspectors are in the field all the time. I'm kind of the office body for them. So if there's a complaint that needs to be filed or any sort of, if it were a citation or a C&D or anything like that, I would file it on their behalf, essentially. Doing the paperwork for them, essentially. Any questions on the inspection side? I'll hand it over to Ms. Young.
Okay, so I'm going to explain the process for the investigator, how a complaint starts, and the process. Complaints can be filed online, by mail, or in person. And by mail, it will be done by paper. The initial complaint can come from an inspection by April's team, a third party, such as an agency or news articles, and of course, we have self-report. Opening a case to review and assess the complaint allegations for the Building and Business Board, Health and Medical Boards. The determination process: does the board has jurisdiction? Is the allegation a Practice Act violation? Case opening criteria: if both criteria are met, a case is open. Additional considerations: analysis check if the complainant complete the good cause section. Good cause is when the complainant want to stay anonymous, basically. And so what happens with that, we send the reasoning, the investigator sends the reasoning to which Mary is advice for this board, and then I know she reviews, and then she sends it over to the board and let them review to see if it meet the criteria to be a good cause. If not, we still continue with the investigation. Okay. Amendments 40-1-90, effective May 8th, 2023. Investigation time: within 30 days of the initiations, LLR, we must notify the complainant and the materials. We also send out to the respondent a notice of complaint, which is on the licensee notifications. Licensee responsibility: written reply required within 14 days. Review process: good cause request sent to the board's chair. Compliance oversight: LLR ensures correct procedure. The case assignment: as a lead investigator, I will assign the cases to my team. The investigative investigation order, cases handled in the order received, priority given to cases with imminent danger. Complexity, the investigation length, it can be determined by the complexity of issues, number of witnesses, amount, and types of evidence. Sometimes we may have to travel to actually go in and look at a situation, so all of that can make the process a little longer. Any questions at this point?
Ask you about the good clause.
Okay.
Good cause. Has that always been in effect? Because I've had a lot of people have come to me and said, you know, I'd like to make a complaint, but I don't want my name listed. Is this new?
They changed the
May.
statute. It's when they put that in effect, and then Mr. Robinson reviews it with Mary to see if that.
That was the effective May 8th of
Okay.
2023.
Good to know.
And just to remind you, an anonymous complaint can still be accepted. But if you're going to send it in under a name and say, I don't want my name used, then you have to go through the good cause. And that's because an individual has a right to confront their accuser. And in due process, the individual who is been alleged to have engaged in incorrect, illegal, or wrongdoing, that kind of activity, has the right to know where it comes from. Now, the amendment to the statute made that clear, because there was confidentiality before then. So if the individual has a reason why they are afraid of retaliation, this individual is known to be violent, then they can ask that their name, if given, be kept from the individual who's alleged to have committed the bad act. But there has to be a good reason for that. Right, and that's what good cause is. So, and again, you want to make sure that the investigator has the ability to follow up on a complaint. And if someone is, you can file it anonymously, but if you're saying, I got a bad haircut, or someone hurt my skin in doing this barbering procedure, the investigators can't go forward, because if they don't have someone who's going to provide them with that information, and then if the individual who is alleged to have done that doesn't know who they're saying they did that to, they can't respond. You know, if I say, I got a chemical service and my scalp got burned, well, how was the barber who did that service going to know who that is and be able to effectively present a defense to that? So the fact that someone just doesn't want their name out there, that's really not good cause. There has to be a reason for it, because it makes the process fair on both sides. And I'm sorry to jump in, I just wanted
No,
to.
I love it. Go ahead.
From just being injured, people practice every day without a license, and a barber with a license knows this. Does that fall under a complaint could be filed against someone who's knowingly practicing? I can cut hair. Is that a good, barbers, social media has ruined people's ability to speak out, or willingness to speak out. So is that something that would fall under the good cause?
But that's only if they ask for good cause and it's approved.
Okay.
Some instances when we do get complaints where it is an unlicensed individual, if they can give us the name of the location, the
Okay.
name of the person, then that would be maybe an on-site visit, just to see if that person is working
Okay.
there.
Okay.
But if it's anonymous and we don't get any of that information, then that weakens the case, so to speak. If they can't give us enough information to go on, and most likely if they remain anonymous, if it comes in anonymous, not good cause, then if they remain anonymous, who we going to ask questions to?
Yeah. I got it. Okay, thank you.
Go ahead.
Thank you so much for both of you for the report that you're giving. Will that also under the good clause, and someone requests the FOIA request, will their name still be protected under the good clause?
So FOIA requests go through Kathy Burgess and Holly Beeson, who is over that. There are certain things on a complaint. So if someone requests a FOIA and requests citations or specific information, usually Mike and I will pull that. But when it comes to any kind of disciplinary, that is confidential.
Under that case, that person's name will still be protected.
Correct.
Thank you.
Bless you.
Thank you. Okay, so I think, Billy, we are on, let's go to the next slide, investigating the case. Thank you. Okay, when we're investigating, we're interviewing witnesses, including the respondent. Sometimes subpoenas are needed, coordinating with law enforcement, agencies that's related to criminal investigation, and on-site visits. So sometimes that's when I was speaking about we actually go on site. If a complaint comes in that a person has been arrested, then we are working with law enforcement as well with that. And of course, if we can't get we can't get the documentation that we need, then that's when we will issue a subpoena to get the documents. Any questions?
I do have a question. Would that also, when you speak of, when you get to, say, working with law enforcement, would that also be a time where you're working on investigating a case? Maybe it's extreme, but when it's out of the jurisdiction of the board. So it may be, I mean, in simplicity, it could be unlicensed practice, but taking it further, it could be just repeat of unlicensed practice or operating a shop unlicensed, where the board doesn't have jurisdiction, and you guys are constantly having to go out. Would that be a scenario where you would?
If it's unlicensed practice, we could do a cease and desist. But then we move forward with the investigation after that. But if law enforcement is involved and it is related to the case that we are working on, we can't move forward until a disposition is done by law enforcement.
Gotcha.
And then we can work up to that point, but we have to wait on the disposition of that case before we move forward to presenting it.
And I just want to just kind of get that for clarity, as in, when there are things where you're out of jurisdiction, where you don't, jurisdiction meaning if it's anything that's a non-licensee, right, that falls out of the board's jurisdiction. But with you guys, how would you proceed? I'm just looking at, what if there's an extreme case? Just looking, if there's an extreme case and it goes, would that be an example?
An extreme case of, say, unlicensed practice, we're going to do that cease and desist. From that, it's still going to come before the board.
If I
It
could
goes
just,
before the
sorry,
IRC.
chime in just a
Go
little
ahead.
bit. When we're talking about jurisdiction, we're talking about jurisdiction to discipline versus jurisdiction to issue a cease and desist. It's different things.
Right.
And they do, I think like Renee said, they have to be a licensee, an active licensee, in order for the board to be able to issue some sort of sanctions or discipline. So it's not that there's nothing to be done, it's just it's extremely, extremely limited. We're not going to be able to fine someone or do anything of that nature like you would with the matters that are actually presented to you. If that clarifies a little. Ms. Lee, do you maybe want to chime in as well?
Yes, thank you. So if there is persistent ignoring of a cease and desist, then there are steps beyond that, and I think that may be what you're asking. And do you want to address that, Ms. McMenamin?
Yes, and so at that point, we could seek from the administrative law court that there be some discipline from that court, a more serious injunction. that if they continue on that path, there may be some financial constraints, things of that nature that court can implement. But we've got to get to a point that they are repeatedly, that this is an ongoing issue, that it's a pattern.
Right, and that's why I said
And that's
that's an
very,
extreme case.
yeah, that's very
That's-
rare. That is
Right.
very, very rare that we continue to get those complaints about the same unlicensed person. That's not very common. So it's something to worry about. It's a very good question, but I wouldn't worry about it too much.
Okay, well, I look at it as
Yeah.
if you stay ready, you don't have to get ready. So information, as you
Yes.
gather it, you have something that you could, a reference point.
And vast majority come right into compliance.
Yeah, gotcha. Thank you.
You're welcome, you're welcome.
I'm going to jump in, I'm going to answer this question, I'm sorry I didn't interrupt you. And I would say, yes, you may be aware in your Practice Act that practicing without a license is a misdemeanor offense, and you could prosecute it criminally. That would have to be the solicitor that would prosecute it. And I think as you understand with the volume of cases, that this is a low priority issue, since there are ways that the board itself can address it through the administrative law court. So frankly, I'm unaware of any criminal action across this agency that has been instituted by a solicitor for the misdemeanor unlawful practice.
Well, and I know several of us in ODC are former prosecutors, and we didn't know about those statutes. I'd never seen it in 6 years. And of course, that's misdemeanor, but still, I worked pretty closely with some of the magistrate level courts, and yeah, no, it was not something that we knew existed. So we're not seeing it coming in through law enforcement in that way. I think it would have to be some pretty egregious circumstances.
Well, I've found over the years there are a number of unlicensed practice and barbering take place in the garage, in the house, a friend's property. They can't do anything about it because they're not licensed, yet they're still cutting hair. Is there anything with that, if I were, say, to make a complaint? Does that go into the law enforcement, cease and desist, and then they take it over with that, or you just forget about it?
I don't believe that's something that I could comment on with that specific question.
Well, it does happen. It's happening all the time.
Oh, well, no, yes, there's definitely unlicensed practice occurring in homes, but there's a portion of your question that I couldn't answer
Yeah,
that
okay.
for you.
It's actually hard to catch someone that has never been licensed.
And it's frustrating for those who have gone through the process to get their license and to do everything properly, and then you see right 2 blocks down, somebody's cutting hair.
So it's kind of hard to catch people. Some people have stated to me when I was an inspector that people do hair on Saturdays and Sundays that's unlicensed, never have obtained a license because we don't inspect on the weekend. So therefore, they would have free reign for the weekend.
And if there are instances of unlicensed practice alleged to be in someone's home, agency doesn't inspect in someone's home. So it would have to be from an individual who has received a service, who is complaining about that. It has to be investigated. And yes, it's recognized that is an issue, but it's not going to stop all the bad behavior.
Yeah, no, I think that covered everything. Yes, thank you for the opportunity, though, Renee.
Okay, an expert review process. We have only had to use an expert review once, and this board was not one of them, but I supervised 9 boards. But when we do need an expert review, Tracy, can you explain the process, how you select the person? We will onboard them.
Right. So it's kind of like when we do the IRC members. So the difference is with an expert reviewer, the IRC member has access to all the investigation material, so they will have that communication with Leanna and the inspectors and the investigators to kind of decide what, what level of discipline, if there is, but they can't testify. So the expert reviewer takes it to the second level where they have the ability to review that information, and if it is a formal complaint and there is a hearing, that allows that person, they've reviewed all that material, and they have the ability to testify that as an expert, this individual violated one of the regulations or statutes. So
Practice, subpar
or-
practice.
Right. So it allows them to have that ability to speak on the behalf of the industry. So so sometimes, and we may have, if we have cases that we may have someone that we need to be an expert reviewer, we may ask y'all to approve that, and we would do the same thing as we do with an IRC. We would ask them to submit a resume, and then y'all would vote on if you think that they meet the qualifications to be that expert reviewer. And they would only be an expert reviewer when Office of Disciplinary Counsel and the investigation team feel that they need it.
Okay, so if that is needed, we continue with the process as normal. This training is set up for more than just one board. It's across the board. So you see we got nursing, medical, dentistry, all of those boards, they use that a lot. After everything is done with an expert reviewer, it would then come to me. After the full investigation is done, the expert reviewer has reviewed and all of that. So once they submit to me, I think Billy, there we go, okay. They submit all the cases to me. I have to review and approve those cases, make sure that everything is done that we could do. When it's completed with me, that's when it goes to the IRC. And that's when IRC members, they look at it, they decide what course of action that they would suggest to the board to be taken. Okay. The IRC, Investigative Review Conference, it is comprised of the investigator, lead investigator, ODC attorney, board exec, and professional members. So the IRC role conducts throughout the year. We have so many meetings per year. Part of the investigation process is a non-public body. Assessing finding related to alleged Practice Act violations, that's evidence review. Case recommendation provides disposition suggestion to the board, consistent of goals, aims to align decisions with boards handle of similar cases. Any questions? The board review of the IRC report. This is when we ask for approval of our cases where we have the allegations and then we have the IRC logic. That's where you guys have the authority to approve what the IRC recommended or to disapprove. Any questions? The board IRC report, The key points about the IRC report: it has no identifying information. That's why I think you only get the case numbers. Limited case details to prevent potential bias. The board review of the IRC report, these are your options. You approve the IRC recommendations, you can edit them, or you can pull the case for further investigations.
I have a question, Mr. Chair. When you said that we can pull it, meaning that board members can pull this information?
You will not approve the report and tell us, that this is not enough information. So what, if the IRC recommends a person gets a formal, say, a letter of caution, you deem it may be more than that, then you disapprove that case and we have to go back. These are requirements for a formal complaint. The regulatory framework, board allows the Administrative Procedure Act 1-23-10 in 1976 as amended, governs state agency rulemaking and regulations. The key responsibility: uphold due process rights, follow rules of evidence in proper notice. The disciplinary action requirements: licensee must have violated the Practice Act. Board acts as finder of facts and tier of law. Board orders require evidentiary basis to withstand appeal. Any questions? The requirements for a formal complaint: jurisdiction and authority, professional, occupational license, establish board's jurisdiction. If respondent is unlicensed, only a cease and desist order can be issued. Formal complaint process: board approved formal complaints are transferred from OIE to ODC. This is where this is sent to the Office of Disciplinary Counsel, which would next be for Leanna.
Hey, I think it's still, good morning, everyone. I've been with you guys with this board for a few years now, but just to go back over who I am, I'm Leanna McMenamin. I am your attorney in the Office of Disciplinary Counsel that is assigned to present disciplinary matters to you all. I mentioned earlier, I have a background in criminal prosecution. I did that for about 6 years before I came to LLR, so this is all very similar in the setup and procedures. Now, this slide in particular is just to give you an idea of how the Office of Disciplinary Counsel, or ODC, is set up. Tina Brown is our Chief Disciplinary Counsel, so the head of ODC. And then in addition to Ms. Brown, we have 5 supervisory attorneys. But there are, gosh, there's probably about a dozen of us now. And we are assigned to various boards. I am the attorney that is assigned to yours, and I do feel that that is a lucky assignment. For whatever it is worth, I have enjoyed working with you all over the last few years. Our general duties for each attorney in ODC include case prosecution and defense. Case prosecution, that's what you see me doing in here with the final order hearings, but also in the hearings with the hearing officers that are appointed by you guys to hear those full evidentiary hearings, the presentation of the MOA or the SOF, things of that nature. You'll see that there's also argument of defense of board-issued orders. So let's say someone appeals a final order of this board and it goes to the administrative law court. There is an attorney in our office who would handle that appeal and defend that determination. It is not me. But that is another aspect technically of the ODC duties. Legal documents and preparation. So again, the consent agreements, the memorandums of agreement, the stipulations of fact, those are prepared by the Office of Disciplinary Counsel and other case-related legal documents. Technically, temporary suspension orders, evaluation orders, the C&Ds, those cease and desists, reinstatements, all fall under ODC's responsibilities. But you will see, as Ms. Young mentioned earlier, there are some things throughout this PowerPoint that are not applicable to every single board. So evaluations, that is not something that statutorily you'll have the authority to order. So that's just one of those things. Of course, I manage my cases and my hearings for this board, scheduling them, making sure that we are moving cases along as efficiently as possible. That's a big aspect of what I'm doing. And then collaboration and negotiation takes up quite a bit of time, interacting with respondents. Most of yours are unrepresented, but interacting with their counsel if they have an attorney, also potential witnesses, complainants and other agencies, and then of course working very closely with the Office of Investigations. If either of us have questions at times, there's a lot of collaborating going on there. On the next page, you will see that if you approve a case, so on the IRC report, the cases that you approve for formal complaint come to the Office of Disciplinary Counsel. The dismissals, the LOCs, those do not come to ODC. It's your formal agreements. Now, most of those are consent agreements or memorandums of agreement. Technically, your respondents do have the option of a stipulation of fact, and I'll go into what each of these are in more detail. It's just the stipulation of fact usually just doesn't really work out. It doesn't make sense in most cases, but we do have some of those options. The alternative resolutions you see over here, technically someone could voluntarily relinquish, so permanently give up their license to practice barbering of any kind, no matter what their licensure at that time is. They'd never be able to practice as a barber of any degree going forward if they wanted to do that in lieu of discipline. I don't believe I have seen anyone do that yet. Of course, they can have a hearing if they do not wish to resolve it via a written agreement where we're agreeing to some of the details. A panel hearing or a full evidentiary hearing is like a trial, y'all know that, and everything is up in the air. It is all up to me to prove what has occurred, and the respondent has their opportunity to put up their defense. The deactivation agreement is not applicable, and so we'll move on to the next page, which comes a little bit back to more detail of what the types of written agreements that these respondents can enter into to resolve their disciplinary matters without having to have that full evidentiary hearing. The difference, really, what that comes down to is what the respondent is willing to agree to. And that category falls into facts, violations, and sanctions. If we're willing to agree to all three, that's your consent agreement, and then it sort of trickles down. On the next page, let's talk about the consent agreement. First and foremost, a consent agreement is only an option if your professional members in the investigative review conference approve that. Okay, so they are working off guidelines that y'all established several years ago about what discipline is appropriate for certain cases. And if the factual scenario and the violations fall within those guidelines, we talk about whether or not to issue that consent agreement and down to the detail of what those parameters are going to be. And so usually it's the level of the fine that would be appropriate. But that's only me giving that option to a respondent if your professional members have already approved that at the IRC, and then a formal complaint is approved by the board at the board meeting. The consent agreement, a respondent would sign this and enter into a consent agreement to resolve their case if they agree to the facts as stated, if they agree to what specific statutory or regulatory violations occurred, as is asserted in the agreement, and if they agree as to whether or not the sanctions or discipline are appropriate. This is the most efficient means for a respondent to resolve their case because they do not have to appear in front of a hearing officer and then subsequently the board. That agreement is sent to your board chair for approval. Now, let's say they don't want to sign the consent agreement. Well, we can talk about other agreements and/or just going straight to a full evidentiary hearing. Or if it's not approved, then we take the step back and we kind of start over. The next type of agreement that we're going to talk about is the memorandum of agreement. Here, what we are all agreeing to are facts and violations. What, if any, discipline is appropriate is ultimately up to the board, but the hearing officer would be presented the MOA. The respondent is given their opportunity to present mitigation, and then we get that recommendation from the hearing officer that I then later present to you guys at the board meeting. This is also still a little more efficient than the full evidentiary hearing for a respondent. You're going to see these when it's quite obvious what happened, but they still feel that they want to present their mitigation, let the board hear their side of what's going on. As far as the facts, they can testify and provide mitigation. They can submit letters of support at that hearing. The state, however, is a little more confined to what's in the document itself. And then you see RPP here. That's the South Carolina Recovering Professional Program in regards to additional testimony. Again, that's not applicable because we do not have the authority statutorily to issue an order requiring evaluation. So just going to skip over that a little bit. And then on to the next page, the stipulation of fact. So here, a respondent would only be agreeing with the facts. Like I said earlier, this doesn't work out a lot because usually, inevitably, if you're agreeing to the facts, inevitably you're admitting to a violation. Now, there are some cases where this is still quite appropriate. I understand where they're coming from, and it's not necessarily ever off the table. It's just, it's not usually a viable or reasonable outcome. At this point, we're probably just having a full evidentiary hearing. But that would still, again, like the MOA, they have their opportunity to present mitigation, their side of the story, their version of what occurred, and anything that they want you to consider in what, if any, discipline is appropriate. And the determination of the violations and sanctions is up to the hearing officer and then ultimately up to the board. Panel hearings. This is your trial. There are opening statements, we call witnesses, we enter in evidence, the respondent has the opportunity to do the same, and there are closing arguments. And at the end of the hearing officer will make a recommendation as to what, if any, discipline is appropriate. Did the state meet their burden of proving the case by a preponderance of the evidence for the various violations? And if so, what, if any, discipline is appropriate? And then the final order, of course, goes to you guys at a later date. Typically, what you're going to see here with the panel hearings is really we're calling investigators and/or inspectors. Usually, we do not need an outside witness, the complainant or anything of that nature, in order to proceed because it's really coming down to what we're finding when we're going in for the inspection or the site visit. That's what's got the strongest evidence, and we're very fortunate we're able to move forward in that way and not having to rely on others in order to execute these cases. So once you have the final order hearing in front of you for these matters, your options for disposition as a board are as follows. Outright dismissal of the case. That could be for various reasons. You have the letter of caution, which is a private, non-disciplinary option that stays in the respondent's file. And again, it's private. Only you guys and me and the respondent are going to know about that. This would only maybe come up later on if we see that we have a repeat offense of like the exact same nature. And that would be, discussed with the investigative review conference. If we've got some prior issues and what do we do now? How much grace do we give at this point? What's going on here? There are violations and sanctions. And then you see private disposition, but again, that is not applicable to this board. There's no statutory authority for a private disposition. If it's private, it's a letter of caution. You can't say, okay, pay the fine, but we're going to keep this a private document. It's going to be a public reprimand, no matter what. And so when we're talking about the sanctions for that, there's the public reprimand, which could include really for you guys, it's going to include the fines. Potentially, there could be supervision or suspension or probation if it's serious enough and you see such a repeat offense. I know I've seen that a little bit in the last few years with the rare. Most people kind of get their act together after the first or second time of an issue. We do not have many egregious repeat offenders, but of course, those suspensions and suspensions with stay or probations are out there as an option. Now, on the next slide, yeah, this one, sorry, thank you. The respondent's due process rights. Of course, they are entitled to notice of the complaint and the complainant's identity unless that good cause is granted, as was discussed earlier. And they have a right to respond to the allegations. They have a right to be represented by an attorney. Of course, that is at their own cost. And they can always surrender or relinquish their license. The surrender is temporary, and that's really going to be more if they're looking at something really bad has happened and the board may need to temporarily suspend a license. They could surrender in lieu, or they could relinquish permanently in lieu of discipline. They have right to access the evidence and to a case resolution, so the documents that we can turn over, we provide to them so they can prepare their defense and their mitigation, and trying to get this resolved as quickly as possible for them. They may object to state's evidence during hearings and present their own admissible evidence, and they have the right to appeal to the administrative law court and beyond. So some other legal discipline-related issues. Like I said, temporary suspension orders, but that we really see mostly on the medical side. Cease and desist orders are applicable. We see those quite often with your board, unfortunately. I know that was something discussed earlier. There's also the voluntary surrender and the voluntary relinquishment. The order for evaluation and the recovering professional program is just not applicable due to statutes. And really, I feel like we've covered TSO, the ORE is not applicable. We've covered cease and desist orders earlier unless y'all have more questions, but I think there was a pretty thorough discussion, so I'm just going to breeze through that. Surrender and relinquish, we've covered that as well. Recovering professional program is not applicable due to statute, and there's 2 slides for recovering professionals. And then that is it. But of course, I am open to any questions that you might have. I know that was a lot of information to cover.
I have one tiny question.
Yes.
Okay. Where is the public reprimand publicized?
So orders of the board are on your board website through LLR, so your
That's all?
section. Mhm.
Okay.
Anyone can go and look up by name a licensee and see what, if any, prior public discipline has occurred. No, you're welcome.
I would like to know, please, if there is a cost for all of the work that we just heard and you all presented today, other than the hearing officer's stipend. Is there a cost, an extra cost to the board?
Technically, investigative costs could be ordered, but that's up to the board. It is not something that I have sought in the past because they are usually nominal, and the fines and things are already so set out with this board that usually covers the discipline.
So when the public officers are called, that's no extra charge for those paperworks that may have to be submitted?
So I may not be understanding your question. Could you ask that again another way?
If I'm not mistaken, if I heard it correctly, some of the cases that come before your desk, you may have to call the local sheriff or police department to help support you in the findings. Who pays for those costs for those forms that have to be submitted to the persons that are on our board, that are licensed by this board? Who
So-
pays that? Or is there a fee?
Generally, there's no fee. They're just provided.
Thank you.
We do, when it's formal complaints, in the case, it is an affidavit of cost that is associated with the case, and that's determined by the amount of hours that we worked, and of course, if you traveled, it's more. So all of that is in the file when a formal complaint is done.
Question, Mr. Robinson.
One moment. Were you asking about how much it costs the board to do these things?
That's right.
Okay. In your, the report, the financial report we get, it breaks out the cost that portion of this board pays for their services.
But if I'm not mistaken, it's not broken down. It's just, I see O, i.e. legal transfers.
So if you go back to my board report, where it's the financial cost, but you also have to, so the investigators and the inspectors, because they work for multiple boards, that is divided between each board that they work for. So the cost of it does not come completely out of the Barber board. Their pay comes out of multiple boards because they investigate and they inspect multiple boards. Same way with Leanna. And as far as the hearing officers, they get paid just like y'all do when you are here.
Like the example that I use, if a sheriff have to be called or police have to be called, that is okay. They answered by the show of their head. Thank you.
If you're saying if we had to call a police officer, or
To submit documentation of being subpoenaed, or when you need help going in a place where it may not be as safe. You may have concerns about going in there alone. Any type of fees that could occur, who pays for those?
oh, okay, I don't think we have ever used for us, but April, have you guys had to use the judicial system?
I was just going to say, there's actually no cost associated with that. So if we subpoena records or we request a police report, there's no fees associated with that. And anytime that we feel safety is an issue, that is a public service. They will provide their services at no cost.
Thank you, Mr. Chair.
With that, thank you so much, everyone.
Thank you.
And now I'm going to talk to y'all very briefly, because you've heard a very detailed description of how a complaint, how a disciplinary matter works its way through the system. And that's not all that you do. So I'm here to talk a little bit about the laws and principles that impact how you make your decisions, and the laws and principles that impact how you conduct yourselves as board members. So I think y'all have a really good grasp that regulation is a limited means of directing how someone practices a profession. Everyone has the right to practice a lawful profession. In some instances, when public safety can be impacted, the state has the ability to provide a means to the public to ensure that those services are provided safely. So what y'all look at as a licensing board is balancing the right to practice a profession with the public protection aspect of what it means when you're practicing that profession. So you're looking at not overprotecting the public so that it's so burdensome to the practitioner that they can't move forward, and you're not making it so easy to practice a profession that the public safety aspect of it is negated. So you're looking for finding the middle ground. And to do that, you do that through the disciplinary process, making sure that someone who has a license is practicing at a minimal level of competence, or if they don't have a license, that they're stopped, there is cease and desist. And you're also looking at what it means to have a license. What sort of minimal training do you need? Because you don't want to overtrain someone, right? You don't want to make it so hard to get a license that you can't accomplish that goal. But what do they need? What do they need to know to do what they do safely? So you establish regulations. Y'all have been through the process where you look at your regulations and decide, does that still meet the needs of the profession as far as the competency aspect? And then you have application hearings, as you had here today. You look at someone, whether someone's criminal background could impact the public. When you're looking at that, you're not looking at the fact that they just have had a criminal conviction in the past. You're looking at how that conduct can impact their ability to safely practice. And when you are putting a condition on licensure because of that, you have to state why. And that's what you did today. Said, look, the issue is whether that individual is going to continue to still not be risky to the public with the charge in question. And you're doing that by requiring the proof of that at the end of a year. So you are looking not to keep someone from getting a license, but again, to make sure that they have the competency and maintain that competency to do so. Your conduct is different as a board member that is a regulatory board as opposed from any other boards you may have served on. And that's because you really had this almost quasi-judicial function. You are sitting in judgment of someone's ability to practice either on the application side or on the disciplinary side. So you have to have ethical, due process, transparency, the Freedom of Information Act laws, confidentiality, and constitutional provisions that impact how you do your job. You have the board member reference manual. That is very well written. If you ever have questions, you might want to kind of go there first and see if that gives you some sense of what you need to do. Of course, you can always contact me. That's what I'm here for. But the things that you look at, of course, are the Practice Act and regulations. And you look at whether or not someone has followed your sanitation requirements, has your education training, and is meeting the minimal level of practice. And that starts out where you go with how you conduct yourself as board members. The United States and South Carolina constitutions have requirements that if you're going to deprive someone of a liberty or property interest or a right to practice a profession, that there are certain minimum elements that must be part of that proceeding. That's the notice, the opportunity to be heard, and the right for review. So that's why someone gets notice of a hearing. That's why they come to this hearing and they are apprised that they have a right to be represented and that you move forward in sunshine, not behind closed doors, so that there's the public is assured that what you're doing is for the benefit of the public with the acknowledgement of the professional's right to proceed. So you have the Freedom of Information Act, and that's why we have an agenda. That's why it's posted 24 hours ahead of time, and that's why we have to stick to the agenda. Because if the public is to know what is going to be before the board, it has to be up in a timely manner so they can make arrangements to tune in or to be here, so they know what y'all are doing. Because we want the public to be aware of how the board operates, the board members need to be aware that talking about board business in a substantive manner really should only be done at a board meeting. You're not going to be behind the scenes saying, hey, have you seen the board member materials? What do you think about this application? You don't do that ahead of time. You do that when you're in open session, when you have the opportunity for the discussion to be full and robust and not secret and behind the closed doors to protect the process. Now, you can leave open session, and you have seen it before. Sometimes the board will go into the closed session which is when there's certain confidential information relating to the applicant or the individual being disciplined that needs to be protected. That's generally, if it's personal identifying information, you'll see that home addresses, social security numbers, financial information is redacted from your documents unless it's part of the proceeding, and is redacted for public purposes. There are also laws that protect information regarding an individual's medical information or their substance abuse issues or mental health issues. And in those instances, the session will be closed to the public, staff will still be present, and any witnesses or people involved in that proceeding are present, but the individual can keep other people out because that's private information. And then the other instance when y'all go into a closed session is an even deeper closed session, and that is when you are receiving legal advice. And that is attorney-client confidentiality allows executive sessions to protect that confidential information. I am y'all's attorney. My legal advice to you is protected. So everyone leaves, and then you can freely ask me questions, and I can give you information that can help guide you in making your decisions. There was something else with closed session I wanted to say. Oh, you also have the ability statutorily to have disciplinary matters conducted in a closed session. So that's not an executive session. But that's because until the matter is concluded, you don't know if it's going to be public or private. You can hear a case and say, there's no violation here. That person should never have had a case brought against them. So in that instance, their privacy is protected statutorily from having the public know that they were accused of something and found not to have had it be true. If there is public discipline issued, there is a public order. It is on your website, and it is out there for the public to see. Another aspect of your job that you have to be aware of is the Ethics Act. That is something y'all are subject to by virtue of the fact that you are considered an arm of the state. It's not just the financial disclosure forms that y'all have to sign and submit every year that y'all are aware of, but you also can't participate in matters where you or a family member have a financial interest or business relationship with an applicant or a respondent that's appearing before the board, or in the subject matter that the board is considering. In that instance, you have to recuse yourself from that hearing. That is mandatory. You would be subject to prosecution under the Ethics Act if you participate in a matter where you have a financial interest or your family member has a financial interest and you did not step aside. That's why you may see a board member who has a relationship with a school, and a student is coming in front of the board for a permit application or something else dealing with that school. They will recuse, and that's because they have a financial interest and it's mandatory. The Ethics Act also requires board members to not lobby as a board member. The board does not have the authority to speak on matters legislatively. So if you have an issue that is of interest to you as a member of the profession, you can speak to a legislator, you can have an opinion, but you have to be very, very careful to distinguish yourself from your role as a board member. I am Mary Lee. I'm a licensed barber. I'm concerned about this legislation that is being proposed because I don't think this is beneficial to the public, right? You have to be very specific to make sure that you are wearing your personal hat and not your board member hat. Because again, that is an offense that could get you in some significant hot water, and we want to protect y'all from that. You still can speak up, but you have to make sure that the individual you are speaking with knows you are not acting as a board member. We also have to be concerned with your knowledge as an individual when you are dealing with something that comes before the board. Recusal is mandatory if you have a business relationship or financial interest. It is not mandatory, but necessary if you have what we call taint which is you have prior knowledge about a case. Someone calls you up. They say, hey, I want to get a license, but I have this criminal background issue. What do you think the board's going to do? You say, well, they have background hearings all the time. You'll be fine. Just come in front of the board. Well, you've gotten prior knowledge. You have facts that aren't in evidence, that may not be in evidence, and you then have to step aside. So if you have prior knowledge of something, if you have heard something in the community about someone that makes you think you could not be completely fair, then you should step aside. There is nothing wrong with that. We are human beings, right? We may have a bias, we may have judgment, we may hear things that we didn't want to hear, but we've heard them. So the fair thing to do for you and for the individual is just to say, I have prior knowledge, I can't hear this case, and let it move forward without you. You do need to be careful if you are going to recuse, as soon as you realize it, to please let Tracy know. We have only 4 board members, and we have to have a quorum before we can hear a matter. So if you're not going to be present, we need to know that so that we can ensure that the other board members will be here and can move forward with that case. And that I kind of touched on that a little bit. It is best practice really not to discuss board business other than at a board meeting, not to answer questions from individuals about issues that the board may be dealing with, not because you have to be bound in this cone of silence, but because of the consequences of having those conversations. As I said, if someone asks you something and you give some advice, they're going to rely on it. And you can't, as one person, know how the full board is going to react, and you don't always know that you're getting the full picture, right? Anyone's going to tell you a story, it's their side of the story. They're going to may leave out some important facts. When the full matter comes in front of the board, and the board sees it differently than you do, they may render a decision or a guidance or a guideline that's different from what you had anticipated. And then the individual who relied on it is in a pickle. You are in a pickle because you gave information that wasn't fully informed when you gave it, and then the board looks bad as a whole. So if you get a question, I would strongly suggest telling them call Tracy. She has so much information, so much institutional knowledge, and if she doesn't know the answer, she knows how to find the answer. And it can be done in a manner that's not going to create an issue for y'all as board members. We're not trying to say you can and you can't. We're trying to protect you so that you and your decision-making process and your decisions are not subject to criticism for any outside influence. Cheryl, everything I wanted to say, just think before you speak. Remember that you're here to both protect the public, but not overly burden the profession. And keep doing the good things that you're doing. I'm so pleased with how this board thinks through their decisions. Y'all are very cautious to take the right way to think through what you do and make sure that your decisions are the best that can be made. I'm always available to answer any questions you have. If you have an issue about whether or not you might need to recuse, if you have an issue about whether serving in another capacity is going to impact your ability to serve on the board, please let me know. I'm here for you. Thank you so much for all you do.
Just real quick, I just wanted to also say, so my communication with Mary, Leanna, and investigations and inspections, I'm kind of the in-between person because they can't communicate. So if you have a question, please reach out, because if I don't know the answer, I'm going to go to Mary or I'm going to go to Leanna or inspections and get you the right answer. They're always open and available for me to reach out to. So just send them to my way, and I'll help as best as I can, okay?
Thank you.
Informative. Yes. Thank you so much for all of you all's. Colorado State Barber Association Conference attendance approval.
So this is when you went to the conference. I thought we had approval, but we did not, so I need to, this is just to get, so we can move forward with your reimbursement.
I was invited to the Panama State Barber Association Conference in July in Charleston. So we need to, I'd like for you to vote for approval for that travel.
So moved.
Second.
All in favor signify by aye.
Aye.
Opposed? Thank you very much. NABA Conference attendance approval. We have our very own Melissa Horton, who's the president of National Association of Barber Boards of America, and she is we are for that. Let's get approval, then we'll get a report in a board report on what's coming. We entertain a motion for approval to travel Charleston, South Carolina for the mid-year.
So moved.
And
Just want to make clarification, all board members, as well as myself, is that? Okay.
motion properly seconded. All in favor signify by aye.
Aye.
All opposed? Thank you very much. Board member reports. Ms. Horton, you want to bring us up to speed?
Yes, sir, thank you. The executive committee is working very hard along with other components of the organization. The event is going to be hopefully well attended. We have a lot of interest that our CEO is receiving, and we need the support of our board members, our barber industry, and the businesses that support us. Our meetings, we have once a month. We're going to have a special meeting on December the 30th. I'm not sure if some of you are going to be called to share input, but the staff, the executive board is working very hard to make sure that the T's are crossed, and we thank you for all the support that we have received so far. It's going to be at the Embassy Suite in North Charleston, and it's a wonderful location because it's across the street from Tanger Outlet.
Okay. Questions for Ms. Horton? Someone else have a board report? Okay, I did go to the Pro V site here in Columbia and in Charleston. I would like to get one of us to go to the site in Greenville. It was well situated, both of them, clean,
To do that.
spacious enough, adequate parking. So our candidate will be well pleased. A few of the little things that I noticed, I did share that information with Pro V. So there are some requirements for your coming. They want you to come a half hour early, et cetera. But let Ms. Tracy know if you plan to go so that she can get that information and what they're asking us to do before when we come.
We're just wanting to make sure they don't interrupt any of the students. So usually it's pretty early in the morning.
Questions? All right. I did ask Pro V about our board member portals. I think they're still working to build that out so that we can look at the pass-fail rate of our students. So, forward to that. All right.
Yeah, I do have a question of where the location in Columbia?
Harbison.
On Harbison,
In that
okay.
strip where Dick's is in.
We're working on the
Excellent.
signage, but right now it's just a piece of paper, but it's between Dick's and the Columbiana Theaters.
Mayor, may I ask Ms. Adams a question about the test? I would like to know, because when the company introduced the program, we were in Charleston, West Virginia, and all of us were not able to attend that conference by Zoom. Is there another one planned in the future that we could probably?
I think they
Awesome.
do those yearly, but I can reach out to them and get information.
Thank you.
Last meeting, there was a question about using the AI aspect of the test prep. Any?
Yeah, we're still working on trying to get some clarification and working out the information. I did want to I know that y'all approved the Barber examination, or the new forms and stuff. So they will be coming online, but what they will also entail is they will be using AI as well. So when the forms are uploaded, so a person cannot move forward without uploading certain documentations that's required. And the application wouldn't be complete until those forms are there. So that's coming soon for y'all's board, where the online applications will have access to those, as well as the AI feature part of it. So a lot of changes coming soon, as well as y'all's website and being updated.
Ms. Adams, is that just for the testing documents or for all documents for our board?
This is for your applications. So for all applications, they will be accessed through online. So if someone wants to apply for a license or a student permit, they can apply online instead of paper application. And the AI feature, which is going across the agency, it's in step of eventually all the boards will be using AI for documentation. Y'all's is in the next couple weeks, I think. We'll have that up and running. So there might be some kinks, so bear with us, but that's something that is being implemented for Barber.
Hey, is it proper to share one hiccup that I noticed with the application now, or wait till after the meeting? Now, when we're filling out the affidavit, the telephone number boots out.
Okay.
Only put a portion of the telephone number. So a lot of applications that I do, I leave blank because it would not full telephone number
Are you talking about the affidavit of,
of student hours and completion of the program.
okay, so that's a form. I will get with DOTS and let them know.
Other questions? Any other board reports? All right, board elections, it's that time of year again. We have two offices, chairman and vice chairman. Okay. For the office of chairman, we'll entertain a motion.
I'd like to make a motion that Mr. Robinson stay in that position.
Second that motion.
Motion properly seconded. All in favor signify by aye.
Aye.
All opposed? Thank you very much. And the office of vice chairman.
Mr. Chair,
Yes?
I would like to nominate Ms. Renee Patton as our vice chair.
Second.
Seconded. All in favor signify by aye.
Aye.
Aye. Thank you so very much, and thank you all for your continued support. All right. Public comments. Public comments. Public comments. All right. All right. February the 9th, 2026. We wish all of you a happy holidays. Please be safe, and we love y'all. All right.
Is there a motion to adjourn?
Motion to adjourn.
Second. Oh, I make a motion to adjourn. Yes.
All in favor signify by aye.
Aye.
All opposed.
Okay. We good?
Opposition?